Ever have a brilliant plan for your home only to run smack into a wall of rules? Well, today we're diving into a legal battle where just 2 feet of building height sparked a full-blown war between a homeowner and his HOA. Let's break down how this tiny measurement dispute ended up in court.
So, picture this. You've got the perfect spot for your dream RV garage. The only thing is, it needs to be 17 feet tall. But here's the catch. The community rulebook says, nope, 15 feet is the absolute limit. It's a classic standoff, right? Your vision versus the rules on paper. So who's supposed to give in? That is the exact question a judge had to answer.
All right, here's how we're going to break this whole thing down. We'll start with the homeowner versus the HOA. Then we'll dig into that specific 15-foot rule. After that, we'll hear both sides of the story, and then we'll get to the judge's final decision.
Okay, so let's meet the main players in the story. On one side, you've got the homeowner, Robert Nickell, with a big plan for his property. And on the other side, you have the Holiday Harbour Property Owners Association, the HOA, the group whose entire job is to enforce the community's rules.
And believe me, this thing blew up fast. Mr. Nickell buys his lot in August of 2018. By early the next year, his request for that 17-foot garage gets denied. By August, he's filing a legal petition, and just a few months after that, boom, they're in a formal hearing, ready to battle it out.
So, what was all the fuss about? You know, this entire legal fight? It all comes down to just one sentence in the community's rulebook, what they call the CC&Rs, and the exact wording here is everything.
Here it is. Section 6 of the Holiday Harbour CC&Rs, it says, structures may not exceed 15 feet in height above lot grade. Now, that sounds pretty straightforward, doesn't it? But, and this is a big but, the real fight was over the meaning of those last 2 words, lot grade.
And this is where it all gets kind of tricky. What in the world is lot grade? Well, according to the HOA and the court documents, it's defined as the highest buildable point on the property. For this specific lot, it meant the elevation of the old house that used to be there. This one definition is the pivot on which this whole case turns.
So Mr. Nickell wasn't just going to take no for an answer. He actually built a pretty detailed case arguing why the HOA was being unreasonable and why he absolutely should get to build his 17-foot garage. He basically made 4 key arguments. First off, he pointed to precedent, showing pictures of other homes that looked like they had garages way taller than 15 feet. Second, he said no harm, no foul. His garage wasn't going to block anyone's view. Third, he claimed a hardship, saying that digging down to follow the rule would cause a mess with drainage on his property. And finally, he argued all this added up to an extreme or material hardship, which meant he should get a special exception called a variance.
But of course, the HOA wasn't just sitting back. They had an answer for every single one of Mr. Nickell's points. From their perspective, they weren't being unreasonable at all. They were just doing their job, enforcing the rules exactly as they were written.
And right here, you can really see the 2 sides talking past each other. Mr. Nickell says, hey, look at those other tall garages. The HOA comes back with, yeah, but they complied by digging down first. He says, my garage won't block any views. They say, the rule isn't about views, it's about fairness. And that hardship claim? The HOA said, look, you just haven't proven it.
Now, this is a really key point. The HOA didn't just slam the door in his face. They actually offered him a clear path forward, a kind of clever workaround. First, figure out the official lot grade. Then, dig down from there. Then you can build your structure. That way, even if the building itself is tall, its total height is still under 15 feet when you measure from that original higher starting point.
In fact, they didn't just give him a method. They gave him an exact number. The HOA actually sent a letter to Mr. Nickell explaining that if he used their excavation method, he could build a garage that was 17 feet and 2 inches tall and be totally compliant. So get this, they gave him a solution that was even taller than what he originally asked for.
All right, so you've heard both sides. The arguments are on the table. Now it's all up to the judge. How is the law going to settle this 2-foot fight?
In the legal world, there's this really important idea called the burden of proof. What it means is that Mr. Nickell, the one who filed the complaint, had the job of proving his case. He had to convince the judge that it was more likely than not that the HOA had acted unreasonably. He had to tip the scales of evidence in his favor.
So what did the judge decide? Well, after looking at all the evidence, the finding was crystal clear. The HOA did not act unreasonably. The judge found that the association had enforced its own rules fairly and, maybe most importantly, had even offered Mr. Nickell a reasonable solution to build the very garage he wanted.
So after all the arguments, all the back and forth, how many rules did the judge find that the HOA had broken? A big, fat 0. The judge concluded they had followed their own rule book, applied it consistently, and acted completely within their legal rights.
And that was pretty much it. The final order came down. Robert Nickell's petition was dismissed. The case was over. The HOA's interpretation of that 15-foot rule was the one that stood.
So what does this all mean for you? Why does a 2-foot disagreement in Arizona even matter? Well, it's a huge reminder that when you buy a home in a community with an HOA, those CC&Rs aren't just suggestions. They are a binding contract. This case really shows that courts will almost always side with an HOA that enforces its rules consistently, especially if they offer a reasonable way to comply. It leaves us all with a pretty critical question. When your dream plan clashes with the rulebook, who really holds the power?